looking to understand Part 36 offers, then check out our latest video.
So this is something else that's been in the news this week, and this is all about Prince Harry. And the reason I thought, because I was up quite early watching Good Morning Britain, so they were chatting all about the fact that there was the potential of a settlement between Prince Harry and the newspapers.
Yeah.
Now, the reason this was significant is because apparently for years and years and years, Prince Harry's been adamant saying, I will not settle for any amount of money. I want to take them to the cleaners. I want to take them all the way. And what they were saying on the TV as well, there must have been a significant offer. And they tried to explain Part 36, and I'm not going to step on your toes at this point, Hayley, but they were trying to explain Part 36, and they didn't do a bad job, to be fair. They didn't do a bad job of explaining it.
Yeah.
But I thought at this point that would be something very interesting for you to talk about with your civil background, Hayley. So take it away.
Let's delve right in. So I don't know if it's been confirmed that there was Part 36 with Prince Harry.
I don't think it has been. I don't think so. No, that's just...
But I think the reason that it's being rumoured is because it's linked to the case with Hugh Grant. So he sued the same newspapers, NGN, they're called. I think it's NGN, isn't it?
Sounds right, News Group newspapers or something.
Yeah. And he settled as well, but then came out very publicly and said he really wanted his trial, he wanted his day in court. Because of the rules around Part 36, even if he won, he was liable for millions of pounds in costs. So he had to settle, his hands were tied. The rumours are maybe there was something similar with Prince Harry, and that's why he's reneged on his previous statements that he would not settle. So, let's get into it. Okay, so we'll take a step back first, because I think to understand this, you need to understand the basics of the different types of cost recovery. So we have standard cost recovery, and we have indemnity cost recovery. In a nutshell, standard cost recovery is what you can typically expect if you win at trial.
Okay.
This is where the court will look at what costs have been incurred by the winning party, have a look at what's reasonable and what's proportionate to the case.
Yeah.
You can typically expect to recover around 60 to 70% of your costs on a standard basis.
Yeah.
As long as your costs aren't crazy.
Okay.
To get your costs assessed on an indemnity basis is a lot better. You get a much bigger bite of the apple, so to speak.
Okay.
To do this, the court usually needs to be satisfied that the party paying the cost has acted unreasonably. If the court agrees to assess your costs on an indemnity basis, you can usually expect to recover up to 80%, sometimes more.
Wow.
So indemnity basis is much more of a penalty than costs being assessed on a standard basis.
Right, I'm with you.
That makes sense so far?
Yeah.
We've talked about this in the podcast before, and most of you, even if you have a fundamental understanding of litigation and disputes, you know settlement is important. Parties are encouraged to settle. If you ignore opportunities to settle, the court can punish you when it comes to cost recovery, cost assessment, etc. So Part 36 is Part 36 of the Civil Procedure Rules, and it sets out cost consequences of Part 36 offers if they're not considered properly, if they're not accepted when they should be.
Right.
So these offers are made on a without prejudice basis at the time. So that basically means they can't be brought up at trial. You can't say, but judge, this isn't fair because I made him an offer to settle and that's why I should win. No. Courts don't know about these offers until after the determination is made when it comes to costs. So the CPR sets out lots of different conditions that need to be met for it to be a real Part 36 offer.
Right.
Things like it has to say it's a Part 36 offer. It has to give a designated period for acceptance, which we call the relevant period.
Yeah.
Typically that's 21 days.
Okay.
So after the 21 days, the relevant period expires. And that's important. And we'll come on to that in a moment. Let's use the scenario where an offer is made from the defendant to the claimant. Claimant doesn't think it's a good enough offer, so the claimant rejects it.
Right.
Yep. Basically, nice and simply, if the claimant wins and the judgment is better than the offer that the defendant made, cost recovery is done as normal because they beat the defendant's offer. Everything is fine.
Yeah.
If the claimant wins, but the judgment is less than what the defendant offered, then that's when the claimant will be punished when it comes to cost recovery.
Right.
So even though the claimant's won, the court can still order them to pay the defendant's costs from the point when the relevant period ends.
Right, okay.
Because they should have accepted that settlement.
Yeah.
So it shouldn't have continued past that point, and the claimant could have saved everyone a lot of money and time. That's the reasoning behind it.
Of course.
So next scenario, we have an offer made by the claimant to the defendant. If the claimant wins and the judgment is less than the offer they made to the defendant, then there's no penalties. The costs are assessed as normal, case is won as normal, everything's fine.
Yeah.
But if the claimant wins and they win more than the offer that was made from the defendant, then the defendant is penalised with costs.
Yeah.
So not only do they have to pay the normal cost because they've lost the claim, they can also be ordered to pay the costs on an indemnity basis,
right,
plus interest from the date when the relevant period expired.
I see.
They can also be ordered to make an additional lump sum, which is usually 5 or 10% of the judgment amount, capped at £75,000 usually.
Right, okay.
And again, this is because they should have accepted the offer when it was made. It would have saved everyone a lot of time and costs, and there shouldn't have been need to go all the way to trial.
Yeah.
If the claimant loses, the claim's dismissed, the defendant wins, everything continues as normal. No weird additional cost penalties.
Yeah.
Does that make sense?
That certainly makes sense. So in a nutshell, when you've got your offer from the defendant to the claimant, if the claimant beats that offer at trial effectively, then what would happen in that situation? So let's say the defendant makes an offer to the claimant.
Yeah.
Claimant rejects it.
Yeah.
They go all the way to trial, and the court says they win, and the court says, "Yeah, we'll give you." I don't know. Say the offer was 75,000 to settle, and they get awarded 100,000 at trial.
Yeah. If the claimant wins, and it was the defendant that made the offer, and the claimant gets more, costs are done on a normal basis.
Okay. That makes sense.
Yeah.
That makes sense.
It's one of those things we have to explain it to our clients all the time. It's a much easier concept to understand than it is to explain.
Yeah, I get that.
Because it's so much easier in practice because you're dealing with one of these scenarios, whichever one it is.
Yeah.
So are you the claimant? Have you got the offer from the defendant? Okay, explain these ways, explain this ways.
Yeah, you've only got one scenario to explain, haven't you?
So sitting here and trying to explain it in a really simple way is trickier than it sounds, but hopefully I've managed it.
Yeah.
So in a nutshell, the Part 36 offer, the Part 36 rules are all designed to make sure that everyone acts fairly and properly when it comes to settlement, and everyone knows if they ignore a good offer, they can be punished when it comes to the conclusion at trial.
Yeah.
The court does have discretion, so these aren't mandatory rules and mandatory punishments. So if the party that should benefit, for example, from the Part 36 has done something, acted unfairly, acted unreasonably, the court can say, well, you're not getting those extra costs, you're not getting that interest, you're not getting them on an indemnity basis, etc. So there is discretion there, but it's still something that everyone in litigation should be very wary of when they get Part 36 offers.
I'm with you. That makes sense. Very well explained.
Thank you.